We shall start with business and immigration law updates. This is written, directed, and hosted here by that famous attorney at law, Mr. Ramesh Khurana of the Khurana Law Firm. This is located in Rockville, Maryland. The moderator here is attorney Kenneth Haber, who questions attorney Khurana on vital issues in relation to H-1B visa status. Let's join these two attorneys in their exchange of legal advice.
Welcome. This is the Capitol Forum, and I'm Kenneth Haber, your moderator. I'm a former assistant United States attorney and former senior attorney in the Office of Investigation. While I might have good credentials, this man beside me has extremely excelling credentials as an immigration attorney. He has clients across the country, across the world. This is Ramesh Khurana. Welcome, Ramesh.
Thank you very much, Ken. I really appreciate for the kind introduction.
It's my pleasure. Every word is well earned.
Thank you so much.
Ramesh, what's the concept of benching in the context of an H-1B visa employee?
Ken, when we are talking about the benching concept in relation to the H-1B employee, that means the employer is asking the H-1B employee to sit on the bench, and he's telling him that I don't have any business for you, I don't have any project for you, and since I do not have any project for you, I cannot pay you. So this is called, basically, you are taking a person out of the active employment status, or you are putting a person in the non-productive status. This would also amount to benching of the H-1B employee if you underpay an H-1B employee. Let's say you say that, okay, now I have got only 15-day project for you instead of 30 days in a month, so I'll pay you for 15 days. It doesn't work for H-1B employee. Regulation is very, very tough. So if you have filed a labor condition application, you have got to pay that H-1B employee pursuant to the labor condition application, otherwise you are on the hook.
That's regardless of whether you have the work for him, is that correct?
Say again?
That's regardless of whether or not you have the work, you still have to pay him.
Yes, exactly, because that person is sitting to obey your orders. You give him the work and he will do it. It's not like that you ask him to sit without work. So this happens most of the times with consulting companies, because they lose certain projects, and when they lose certain projects, and they will say, sorry, I'm waiting for the project to be approved before you can be getting paid. And that person can simply file a complaint with the Wage and Hour Division of the Department of Labor, and Department of Labor will definitely initiate an inquiry, and Department of Labor will make sure that this H-1B employee gets paid.
I take it this benching is a violation of the H-1B payment obligations as well.
You are 100% correct, Ken, because you have undertaken the obligation which you stated in the labor condition application, based on which the labor condition application was certified by the Department of Labor. So once you have stated that obligation, you have got to pay that amount of salary to the employee, and if you do not pay that employee, that's called shortfall in the wages, and you are liable for those shortfalls. And these shortfalls could be in various ways. Let's say you say, I will pay this employee $80,000 a year, and you pay him just $50,000 a year. But of course, the exception could be only in the instance when that employee asks for some vacation, and he asks for vacation which is unpaid, then it is understandable. Then of course the employer is not liable.
Can an H-1B employee move to a new employer on his visa in a situation where he finds a new job with another employer?
Yes, Ken, definitely. We have the provision of moving an H-1B employee from one employer to the other employer when a new petition has been filed with the USCIS, and this is under American Competitiveness Act, which is we call it AC-21. And under this AC-21, once a petition has been filed, you can port or you can move from one employer to the other employer just with the evidence of filing of the petition. But most of the times we recommend that better see for the approval of the petition before you move. And we recommend, why don't you file under premium processing? Under premium processing, the H-1B petition usually gets approved in 7 to 10 days, though of course USCIS as per the regulation can take up to 15 calendar days unless they have a request for more information. But most of the times, if an attorney has worked well on the petition, it gets approved in 7 to 10 days. And we say, okay, Mr. Employee, now you can move from employer A to employer B, so that he is in a safe zone.
That's good. Otherwise it'll lend itself to indentured servants.
Yeah, definitely, let's say that a person moves without approval of the H-1B petition by the USCIS, and it doesn't get approved at some point. Now he is in really trouble because he has moved from his previous employer to the new employer. So he lost his job, and now he is waiting for the new employer to pay him, but he cannot work because there is no authority given by the USCIS. So that's why it's better to take some appropriate steps, and appropriate steps are see the approval of H-1B petition before you start working with the employer. But of course, sometimes what happens employer doesn't want to pay premium processing fees, which is $1,225. In that kind of situation, person gets stuck. He is to just file the petition and wait for the approval, which may take 3 months to 6 months.
Wow. If you want your employee, it's probably a good idea to pay the extra $1,200 if you're in a crunch.
That's right, to be on the safe zone, yes.
When do an employer's payment obligations cease as to an H-1B employee?
The obligation would cease for payment to the H-1B employee when that person's job has been terminated. That could be one situation. And if the job is terminated, then the employer has to notify the USCIS. They have to inform them that this H-1B status should be terminated. That's number 2. And number 3, let's say the person has come from India. Now he has lost his job because you terminated his job, and this person has to go back to India. So you have to pay for the airfare so that this person can go. And let's say that person has a family, wife and children. Employer doesn't have any obligation to pay for the wife and children. Employer's obligation is just limited to pay to the H-1B employee. So these 3 conditions must be met before the payment obligation would cease. But sometimes I would advise my clients that if labor condition application is unexpired, let us say that LC was approved for a period of 3 years, and this person has been working just for a period of 1 year, and 2-year period has not yet lapsed. I would say withdraw this LCA, so that there is no point why this LCA should remain alive. So when all these conditions are complied with, then the payment obligation would stop. Otherwise, I have seen many worst conditions where the employees would come back and they will ask for payment of their wages, because they will say, I did not receive any termination letter, I never resigned, I never quit my job. But of course, one thing I would like to qualify here, if a person resigns, then he doesn't have to pay him transportation back home, because he chose to lose that job. That transportation for back home applies only when the services are terminated. But of course, even if he resigns, the employer's obligation is to inform the USCIS that this person is no longer working with us and his H-1B status should be terminated forthwith.
It seems that termination of a position could possibly be abused at times.
Yes, it is, undoubtedly.
Can a H-1B person visit their home countries and stay for a few days or a few weeks during their H-1B status?
Yes, they can, absolutely. Because once the visa is issued in their passports, usually it is up to the period of approval of the H-1B petition. In most other circumstances, it is for a period of 3 years. Now, if a person has stayed here for 1 year, so he has 2 more years to go. And if during the remaining period of his H-1B status, if that person wants to visit his or her home country, no one can stop him. Definitely, he can visit the home country. And sometimes, we have seen in our practice, these H-1B employees have to go overseas because they have got some assignments in their foreign offices. USA company is having an office in UK. So, that employee has to go and train one of their employees at UK office. So, they have to travel. So, in that kind of situation, there is absolutely no restriction or no bar.
When a person goes on vacation and they're going back to India or they're going a good distance away, not just to Ottawa, they might be gone a month, 2 months. Is there any way that they can recapture that time for their visa period?
Yes, Ken. Statute is very clear in regard to recapturing of time which is lost in terms of physical presence in the United States. When we are talking about 3 years or 6 years, whatever is the period of H-1B status, that is the physical stay in the United States. And if a person has stayed outside the United States for 6 months during the period of last 6 years, that person can recapture the lost physical presence time, 6 months. So, that means the H-1B status period would be extended beyond 6 years. Now, the question would be what kind of evidence we need? The evidence could be produced in terms of what we call it I-94, like when did person leave this country, United States, and when did this person return. And then we can also support from the passport record. So, the onus is on the employee to prove that I was physically not present in the United States for 6 months, 5 months, 7 months. So, by way of this evidence, the employee has to persuade the USCIS to grant the extension for the physical period lost in the United States.
Is there any particular documentation that an employer should generate in order to protect himself from the employee claiming that he wasn't paid during that time and that he was ready and willing and able to work, but in reality was out of the country on vacation?
No, that's a very good question. So, basically every company has its policy for grant of vacation. So, of course, that vacation period request should be received in writing, and this should be properly recorded, and there should be a proper communication with the employee that you have been unavailable for this period because you were on vacation. It is not my fault, not that I took you out of the active status of employment. You chose to be away.
Wow, there's really a lot of things you have to be aware of when you're dealing with these H-1B visa employees, if you want to protect yourself as an employer, isn't there?
Yes, Ken. Regulations and laws are very, very complex.
Yes. Well, thank you very much for being on the Capital Forum.
Thank you very much, Ken. I appreciate that you invited me in your studios to answer these questions. I thank the audience as well, and I will advise the audience that if you have any questions, please address to your immigration attorney. Now, we have a very complex set of rules and regulations. Always stay tuned. Thank you so much.